Today VLearn is with Sarah Henchoz, who is a partner in employment law at law firm Allen Overy. Sarah, let's first of all just bring viewers up to date with the subject and the landscape around whistleblowing. It seems to be a subject which is increasingly rising up the corporate agenda.
Whistleblowing is very much top of the corporate agenda at the moment. Somebody blowing the whistle about something you've done as a business has a huge impact on your business, on your brand, on the trust value that customers have in your brand, on your position as an employer of choice. Why would someone want to go work for an organisation that's been found to have acted in an inappropriate or unethical way? You can't open the papers without reading about whistleblowing at the moment. You can read it about the public sector, prison services, healthcare services, not just here in the UK but overseas as well. The issues with Edward Snowden in the US, for example, has been very highly publicised. Companies really need to think about having proper whistleblowing safeguards in place. They need to really encourage their employees to step forward and feel they can whistleblow in a safe environment, but also make employees aware that there are proper channels for doing so and how that will be actually carried out in practice. I think the other reason whistleblowing is very much on the agenda at the moment is there's been a lot of change in the legal side of how the test for whistleblowing has developed. Historically, it's become a very broad test so that an employee can blow the whistle about any issue that they consider to be a legal breach. Now that could be something that only just relates to that employee. So an employee saying, well actually I think I'm being bullied by my manager would be a breach of a legal obligation, which would amount to a protected disclosure for whistleblowing purposes. Now, I think if you ask most members of the public what they think whistleblowing is there to protect, they would give the examples of public sector, hospitals, hygiene, construction, health and safety, those kind of issues, whereas actually it was being used for a much more specific and narrower purpose. So the courts or the legislation now has developed a much more specific test and introduced an element of public interest. So now the court will look at it and say, well, actually, is this matter that's being whistleblown about a matter that's actually in the public interest? And if it is, then that will constitute a protected disclosure. Now, you can kind of see how some employee lawyers will be able to spin the issue. I gave the example of bullying to say, well, actually, bullying's in the public interest because surely all employees should know that if there's bullying going on in an organisation. And in fact, perhaps shareholders need to know about that, customers need to know about that. Would you want to do business with an organisation that's known to bully? But I think it's going to be very interesting to see how the courts handle that, because I think very much the intention is to try to capture those big ticket things that really do have a genuine public interest element to them.
Would you say there are industry sectors which need to take this subject more seriously than others?
I think really whistleblowing should be the top of everybody's agenda. It's certainly not something that only affects the public sector or affects a regulated sector. Every company needs to be concerned about the impact that it will have on their brand and on their business. And obviously the ones that hit the news more are the ones, the public names that we've all heard of and the industries that people are much more interested in. So for example, if you were an airline and you had somebody blowing the whistle about health and safety, people are going to take note of that, people are going to be interested about it. It's going to have more of a detrimental impact on your business. Even if that issue turns out to have no merit to it, it's already been in the public eye by then. You've already lost some of the control over the message that you want to get out. So it's very important that you've got a plan in place to deal with that before you've even had the investigation, as it were, to see whether there's any merit behind it. As I mentioned, employers in a regulated environment need to be very much concerned about this as well. Regulators can impose fines if you have been found to have acted improperly. We've all heard about the LIBOR scandals and the implications from that. So I think with the regulated industry, you've got not just the public interest element, but you've got your regulated and your licensed approach as well.
So Sarah, you're a partner in Allen Overy, a law firm. How does the advice given by a law firm differ from that to, say, for example, an accountancy firm?
As lawyers, we can really help our clients through the whistleblowing process, not just when things go wrong, but right at the very outset in designing a whistleblowing policy and a whistleblowing procedure, helping them set up their helpline, helping them communicate with employees about why it's important to speak up and what the implications of speaking up may be. I think it's also really important, though, to ensure that you have a good crisis team around you. Your whistleblowing investigation may uncover something you weren't expecting. It may be running in tandem with a regulatory investigation if you're operating in a regulated environment. And it's really important that one investigation doesn't compromise the other. The other important thing about lawyers is the advice we give is privileged, and therefore it isn't going to be disclosable in the context of any other investigation or legal proceedings, which advice from other providers would be. So I think it's really important when you're dealing with something that's happening very quickly and could have very serious implications to get the right team in place. Employees can whistleblow directly to the press, so it may be the first you hear about it as an organisation is when it's on the front page. So you will need to move quickly and you will need to engage the relevant stakeholders in doing that.
Sarah, to your knowledge, has there been any consideration given to drafting a law which makes it actually compulsory to whistleblow?
This is something that's definitely been looked at. Public Concern at Work, which is the whistleblowing charity, have actually recommended that that shouldn't be put in place, that employees shouldn't have provisions in their contract saying you must blow the whistle if you find something. That's actually contrary to the Parliamentary Commission on Banking Standards, who think this would be a good idea to encourage whistleblowing, to actually put a positive obligation on people. And I can see organisations moving into that field because actually if you want to control whistleblowing and you want people to use a proper process that you've put in place rather than going directly to a regulator or directly to the press, if you put that positive obligation in the contract, tell people how they should do it and when they should do it, that will help you retain that control over the process.
The IBE findings have highlighted the disparity that exists in the culture around whistleblowing and the attitudes to whistleblowing. What sort of challenges does that throw up for your clients?
We act on behalf of a lot of global corporations who are trying to implement one policy across a number of jurisdictions. So taking one policy, applying it in 50 different countries is a real challenge to try and get consistency, not only because of the legal challenges, but also cultural challenges as well. Whistleblowing is a great example of that. UK law is very advanced and pretty well developed, but other European countries just aren't quite there. And in fact, actually, some of the countries it's quite different. So Portugal, a prime example, if you blow the whistle in Portugal, you could actually be in breach of the obligations you owe to your employer of trust and confidence. So things really have got to sort of move on both from a legal and a cultural perspective before you can get that consistency. The other challenge is implementation. In Europe, we have a lot of issues around consultation with employee bodies and works councils before you can implement new policies. And there's been quite a few examples of US corporations who have come across and tried to implement a policy and actually found that they've fallen in breach of not having those consultations and therefore not being able to implement the policies they've wanted to, or not being able to engage with employees in a way that would actually see this to be a success. So we actually find in our experience it's really important to make sure that you've got local people on the ground who really understand the local challenges both legally and from a best practice perspective.
Just carrying on that theme about the difference in international cultures, the Dodd-Frank Act in the US, just explain how that works in practice.
The US approach to whistleblowing is quite different in the UK. Firstly, you don't have to be a US employee to blow the whistle about some impropriety that's happening in the US. So actually you could be sitting here in the UK, you have a US company who's your parent company, you think something's going on, you can blow the whistle here from the UK. And there's certainly some incentive to do that, and that's where the real difference is between the UK and the US model. In the US, if you are actually party to a company receiving a fine of over $1 million as a result of information that you've put forward from blowing the whistle, you will get a financial reward of between 15 and 30% of the fine or the recovery that the regulator is able to get. I think the highest award so far has been $14 million. So a huge financial incentive for people to blow the whistle in relation to US impropriety. That isn't being implemented in the UK. It's being considered, but actually it's being considered to be countercultural and are not really there to encourage the whistleblowing that people want to do. People think, well, I'm only going to do it because I'm going to get money, rather than doing it because they feel that actually this is the right thing to do.
Without breaching client confidentiality, just explain to us perhaps how you actually practically help firms draw up strategy around this subject.
We've helped firms in a number of ways, not just here in the UK but globally as well. We've involved obviously a number of our external overseas offices as well as our other departments within the London office, so working very closely with our regulatory investigations team, for example. We work closely with clients to help them develop their policies, so drafting their whistleblowing policies and actually drafting some training initiatives about how to sell that to the employees so they understand how it should be used and when it should be used. We also work really closely with clients who receive claims from employees saying, I've suffered a detriment because I blew the whistle, or I've been dismissed because I've blown the whistle. That often runs parallel with other issues, so the employee may be being subject to a disciplinary action at the same time, performance improvement, going through some sort of grievance process, and the whistleblowing is actually something that's running along in tandem, and it's quite important to manage those quite sensitively so that you don't compromise the other. Again, that can involve bringing in specialists from our overseas offices as well, where the whistleblowing element has a cross-border issue to it, which is relatively common these days, particularly in a regulated environment where your regulators will look across border as well to see what you're doing in different operations.
Sarah, thanks for giving us such an interesting insight into the whistleblowing landscape.
You're very welcome.
That's all from VLearn, and we'll see you on the next session.